How a Canada Supreme Court ruling could affect U.S.-Canada refugee flows. A border treaty between Canada and the United States that requires both countries to send back asylum applicants who cross the land border was maintained by the Supreme Court of Canada on Friday. The court concluded that the agreement does not infringe on the asylum seeker's right to life, liberty, or security of the person. However, it remanded the case to a lower court with instructions to examine whether or not the contested agreement infringes on the right of asylum seekers to be treated equally under the law. The judgment was handed down at the same time that Canada was implementing new measures to tighten up the management of its border with the United States. The Safe Third Country Agreement was modified in March by the two countries so that it applies to the whole length of the land border, which spans 4,000 miles, 6,440 kilometers, rather than only at the formal crossings. What do ye as the ruling say? According to the decision of the Supreme Court of Canada, the agreement does not infringe on the right of asylum seekers to life, liberty, and security of the person as outlined in Canada's Charter of Rights and Freedoms, since the agreement contains safety valves that allow some asylum seekers to escape being turned back in specific circumstances. However, the court also discovered an unresolved issue when it comes to the question of whether or not the agreement breaches equality rights. The highest court in Canada declared in a majority ruling on Friday, June 16, that a treaty with the United States to curb the flow of asylum seekers across the shared border is constitutional. However, the justices left the door open for future examination in court. Both the United States and Canada are recognized as safe countries for potential refugees to seek safety as a result of the Safe Third Country Agreement, which went into effect in the year 2004. By the terms of the agreement, refugees are required to file an asylum claim in the first of the two nations they visit. If their claim is denied by one jurisdiction, they will not be successful even if they submit it to a different authority on the opposite side of the border. Opponents of the treaty had petitioned the highest court to rule that the legislation that supports the pact breaches Section 7 of the Charter of Rights and Freedoms, which protects an individual's right to life, liberty, and security of the person. They argued that the United States is not genuinely a secure place for a large number of people seeking refuge. They alluded to tactics such as locking up migrants, treating them to substandard conditions, and separating refugee children from their parents in detention centers. It also stated that women who are escaping domestic or gender-based violence in the United States are subjected to discriminatory treatment, which is a violation of the refugee's right to equality under Section 15 of the Charter. This argument was made because of reports of disproportionate treatment of women in the United States. The Supreme Court concluded that the legislative framework that underpins the deal does not violate Section 7 of the Canadian Constitution. A degree of difference as to the legal schemes applicable in the two countries can be tolerated, the verdict stated, which aligned with what the federal government had argued before the court. So long as the American system is not fundamentally unfair, the judgment read. According to the decision that was authored by Justice Nicholas Kazar, it was stated that, in my view, the record does not support the conclusion that the American detention regime is fundamentally unfair. The court decided that there are safety valves in the Act that are designed to preserve Section 7 rights, even though the court recognized some of the dangers that refugees faced when they were returned to the United States of America. These include humanitarian and compassionate exemptions, which specifically apply to unaccompanied minors and those who have family connections to Canada, but which can also be applied in situations where it is regarded to be in the public interest. In response to the decision that was made on Friday, Immigration Minister St. Fraser stated that there may be certain individual cases where public interest demands that a different approach is taken and those safety valves can kick in those instances. According to Fraser, one of the responsibilities of his work is to ensure that the procedures followed in the United States are up to the requirements set by Canada for a reliable third country. Co-executive director of the Canadian Council for Refugees, Gauri Srinivasan, noted that the safety valves only exist on paper. The Canadian Council for Refugees was one of the groups that participated in the court case. The top court has requested that the federal court do an additional review of the opponent's allegation that the agreement breaches Section 15 of the Charter. This has provided some glimmer of hope to the human rights organizations that were the ones who brought the judicial suit forward. This is a very promising ruling from the court, Srinivasan remarked after the decision was handed down. She stated that her organization and others will need some time to process the verdict before choosing what steps to take next, but in the meanwhile, they will keep putting pressure on the government to terminate the pact. Kasserer noted in the decision that Supreme Court judges weren't in a position to do so either, especially considering that there is no path to appeal a decision made by the Supreme Court. Lower courts did not provide a verdict on the equality issue, and Kasserer said the same thing in the decision. Given the profound seriousness of the matter, the size and complexity of the record, and the conflict affidavit evidence, it would neither be in the interest of justice nor feasible on a practical level for this court to take up the task of the finder of fact, Kasserer stated in the ruling. Given the profound seriousness of the matter, the size and complexity of the record, and the conflict affidavit evidence, we are deeply disappointed that refugees will need to ensure yet another legal challenge and to endure rights violations in the meantime, said Ketty Nivibandi, the Secretary General of the Canadian section of Amnesty International. We are deeply disappointed that refugees will need to endure rights violations in the meantime. According to Fraser, he does not believe that it is appropriate to make a blanket adjustment for women who are escaping gender-based violence, but exclusions may apply in specific situations. He stated that we do not want to simply open the process of asylum for anyone who faces violence when, in fact, they could be saved somewhere else in the country in which they are currently situated. In March, Canadian Prime Minister Justin Trudeau and United States Vice President Joe Biden reached an agreement to extend the scope of the treaty so that it would apply not only at formal border crossings, but also along the entirety of the shared 8,900-kilometer border. Before that time, a loophole permitted asylum seekers who landed between official points of entry along the land border, such as the one at Roxham Road in Quebec, to lodge claims in Canada and have them processed, despite having arrived in the United States first. This was possible because Canada recognized their arrival in the United States as legitimate. Asylum seekers and human rights organizations viewed the gap as a potential lifeline for vulnerable people. However, the enormous number of new arrivals placed a financial strain on local governments and the province, which were required to provide housing and other resources for asylum seekers. The verdict handed down by the Supreme Court brings to a conclusion a legal dispute that was initially brought before the federal court by several asylum seekers in 2007. In addition, Amnesty International, the Canadian Council for Refugees, and the Canadian Council of Churches all took part in the proceedings as public interest parties. The initial challenge was successful. However, it was eventually dismissed as invalid. The same set of groups made other attempts beginning in 2017, all of which resulted in the same unsuccessful results. In both instances, the applicants, who are citizens of El Salvador, Ethiopia, and Syria, traveled through the United States on their way to a Canadian land entry port to claim refugee status. Do you like it? Kindly give your valuable response in our comment section below, and don't forget to subscribe to our YouTube channel for more interesting and informative videos.